We are here in the matter of Dana Braaksma versus Board of Directors of the Sibley-Ocheyedan Community School District. And by the way, does everyone know that Ocheyedan has been declared the most difficult city to pronounce in Reader's Digest? I Googled it to make sure I was pronouncing it correctly, and I'm not sure if I am. Only people from Ocheyedan would know, but it says the most generally accepted pronunciation is Ocheyedan, so I apologize if I'm wrong. As the applicant on further review, Mr. Avery.
May it please the court. I'm Steve Avery. I'm here representing the Sibley-Ocheyedan Community School District. We are asking this court to set aside the decision of the Court of Appeals. In this case, the Board of Directors of the Sibley-Ocheyedan Community School District heard the termination proceedings and decided 5-0 to terminate. Then was appealed to the Iowa District Court. The Iowa District Court sustained the decision of the Board of Directors and then was reversed by the Court of Appeals. The situation here is we want to preserve the termination and provide that 284 provisions for an intensive assistance program is not a condition precedent to a termination for cause, even for performance reasons. I'm not here arguing that there shouldn't be 284 intensive assistance programs. They are an important part of enhancing the educational process and performance. I am here saying that when someone is assigned to a program and specifically rejects it, both to the original superintendent providing the program and then to the subsequent superintendent, and tells that person they're not going to apply, that should not be a roadblock and be able to throw it up as a shield against a discharge for cause under 297.27.
2 months shy of the 6 months when this happened, is that correct? Were you about 4 months into this 284 plan?
That raises an interesting issue that's never come to this court or any that I know of as to whether the summer months apply. I'm going to assume they do apply as part of the 6 months. But if, in fact, it had gone on, they're still, under my interpretation of what was in the record, there would have been an argument that we shouldn't be able to terminate anyway.
That is, there was a period, I think, no matter how you do the math, it was less than 6 months, correct? Okay. Okay. So my question is, you said that it was specifically rejected and therefore we shouldn't have to lean on it. What specifically happened that mandated action before the 6 months was up?
It was the fact that there was not any teaching of Spanish 2 and Spanish 3. If we go to these facts, what happened is that after the April of 19 program was implemented, Dana Braaksma advised the superintendent she wasn't going to participate. Then we move into August, and Superintendent Craig has moved in because Superintendent Bohr has retired. She first meets Superintendent Craig, and he brings up the program, and she says, I'm not going to, it doesn't apply to me. I'm not going to do it. She recants that later.
Isn't there like a meeting in the hallway?
Yes.
Afterwards, and there's an email from Craig where he says, I think we're good now. We talked it over. Yes. So she recants that she's not going to cooperate in the IAP, right? So
That to him.
then, aren't we now under the IAP statute, and doesn't that seem to give the teacher a 6-month period, and then at the end of the 6 months you can terminate them from cause? That's sort of the way it seems to be worded, right?
Two things. If she actually participated in the intensive assistance program, I would agree. However, she rejected it, but then also she was not terminated for that reason. if we can go to the October 11th meeting. She's invited into the boardroom at the end of the day on Friday to meet with the superintendent and the principal. They ask her for her resignation. They tell her that they're putting her on administrative leave and she'll be paid through the year with full benefits. But she's being removed from the classroom for failure to teach Spanish. That is a different situation than not meeting the intensive assistant program. Items 2 and 4, in fact, on the reasons for termination, deal with not teaching. Now, I submit, and our argument is here, that a teacher failing to teach is about the most grave circumstance you can have, and certainly justifies, yeah.
The review application, but it doesn't seem like that issue is directly addressed by the district court, and it seems to have come up for the first time, maybe even during oral argument at the Court of Appeals. And so I guess, how do we determine now whether or not issues 2 and 4 were part of her IAP, and who ultimately gets to make that decision if the district court didn't make that? Is that ours to make now, or does the district court need to make that determination?
Principal, Stan DeZale, pointed out that she had not taught Spanish 2 and 3 to a level that was appropriate for the district. And they found that was cause for the just cause for termination.
Wasn't that part of the IAP? I mean, weren't those things being addressed through this plan?
I don't believe so. That the specific failure to teach is not part of the intensive assistance program.
It certainly seems to me that it's pretty close, right? It's not like she embezzled funds and was fired, or she abused a student and was fired. It has to do with performance issues, and her performance issues were part of the IAP, weren't they?
Yes. Performance was, but the specific problem is the Spanish 2 and Spanish 3, and those arose in the school year starting in August, not in April, when Superintendent Bohr and Stan DeZale were with her doing the intensive assistance program, developing that. Those came up in the fall of, specifically in September of 19, after that program. So this was a situation they felt needed to be addressed immediately. They secured a substitute and had her in the classroom, had that substitute there on the Monday after the meeting, October 11th. On October 14th, they had a sub there. And they felt they needed to move so that, as the principal pointed out in the record, that the students didn't lose that whole year of Spanish. That if they didn't act at that point, there was not going to be anything for them for that school year. And
So there was an IAP in progress at that time, and they didn't revise that to address these new issues. They just terminated her with the IAP that was existing ongoing?
the IAP was ongoing, but the failure to teach arose in that school year. And it is not addressed specifically in the IAP. And
You mean when you say failure to teach?
The level of Spanish instruction at second year and third year is at a higher level than the first year. As indicated in the record, for instance, the replacement teacher.
She wasn't teaching at all. I mean, she was there. She was in the classroom. Teaching to standard.
Yes, they were not learning what they needed to learn to move. As the one student indicated, he wanted to have.
Exact thing that the IAP is meant to address is teaching to the standard.
No, the IAP deals with the 8 standards from the Department of Ed. Now, I suppose in a general term, you would expect that if I'm assigned to teach Spanish 2 and Spanish 3, I'm going to raise the level of teaching to take care of that. But it wasn't specifically addressed. They felt they needed to act to provide these students something immediately. Otherwise, they were going to lose the year, the few students in 2 and 3.
I guess I don't have an issue with the justification for removal, but it seems like those are two separate issues, right? Of what the statute allows and requires prior determination of employment when somebody's on an IAP, and whether or not a substitute should come in because the students are really suffering in this teacher's classroom.
Removing her at the time they did was under the 279-27 discharge for just cause because of failing to teach what these students needed. They needed to act immediately, and the provisions of the IAP is more of a long term to try to improve the quality of instruction. It's a two-way street. And she had already also rejected that. She wasn't performing under it. They determined that, in the fall, that she was not following the IAP, and that
The IAP to give, under the statute, to give her 6 months to comply with that.
the statute actually uses the words that she'll participate. It doesn't say she'll complete, if you look at 284.
6 months to participate then, before she can be terminated.
What we are saying is that doesn't prevent a termination for cause.
Oh, and that goes to, well, I was going to say what Justice McDermott was raised. If it's a completely different for cause, like if she abused a student. But here, and that kind of goes back to my question, it seems like that the district court said, regardless of the IAP, you can always terminate for cause, and even if it's within the IAP, it's for cause, and so you don't have to give her 6 months. And the Court of Appeals came back and said, well, no, if it's within the IAP, then you have to wait the 6 months. You can't just skip the IAP statute and jump to termination for cause. And so that goes back to my original question of, it doesn't seem like there's been a judicial determination of whether or not the basis for the termination was within the IAP or not.
Okay, I agree with that. There's not a specific finding of that. What there was the determination by the district court that there is just cause for failing to teach. I mean, that is my reading of the district court.
My reading of the district court was that the district court said it can be with just cause, can be something that was covered by the IAP, but you can still, the just cause statute can trump the IAP statute effectively. And so if you have just cause for an event that's covered by the IAP, you don't have to wait 6 months. That's the way I read the district court. And the Court of Appeals just said, no, if it's within the IAP, you have to wait 6 months before you can terminate.
Our submission is this is not in the IAP. That's the specific failure to teach Spanish 2 and 3. That is the reason she was removed. And by virtue of the fact they had the sub and were paying her for the year,
My original question then, if there has not been a judicial determination that her not teaching was not part of the IAP, is that for us to decide, or do we need to remand that for the district court to decide that?
in this case, I think it's in the record that it wasn't part of the IAP. And as a result, she can be terminated for it.
So it's in the record, but do you agree with me that there's not been a judicial determination of that? Yeah. Okay.
Okay, yeah.
That if it's something that's spelled out in detail in the IEPs, for example, grade the students, give them a grade twice a quarter, do you have to let the 6 months run before you can terminate for not giving them grades twice within the quarter?
I think that'll be the interpretation. I don't think that was probably the intention of the statute, but it is. But the language is that there'll be participation, not completion. There isn't the language in there, so there has to be completion. But I think that's a fair interpretation, yes. That if she has 6 months or up to 12 months, and if in fact that is the specific reason, yes, I agree with you.
Assume that this IAP said that the teacher shall teach to standard in Spanish 2 and 3. Okay? And let's assume that she's not in the board's view. Could the board then terminate her employment prior to the expiration of 6 months?
I'm not sure we could terminate the employment. I do think that there is always the administrative authority to put her on suspended leave, pay her for the year, and you could terminate her at the year end. That is what, in effect, was tried here, other than there wasn't a termination at the year end. They invoke the termination in November. But they did the administration always has a right to remove from the classroom and replace. Okay.
If this fact pattern were such that the IAP covered the failure to teach to standard in Spanish 2 and 3, the board could not invoke the just cause provision prior to 6 months. Would you?
They would not do that. They could remove her from the classroom, yes. And that's in effect what they did here. Unfortunately, there wasn't a year-end termination. The termination occurred in November, and that brought the appeals. But I guess I'm sorry. Okay, thank you.
You get the last word.
Thank you, Justice Christensen. May it please the court, Mr. Avery. Thank you for having us today. I think this is an incredibly important case, maybe not important to the general public, but certainly important to Dana Braaksma. I am here to represent her today and to answer your questions. I want to start out to maybe clarify the record and clarify the differences between the law in 284 and the board's policy. The 6-month minimum is a board policy provision. That is not part of Iowa Code 284. There is actually no minimum amount of time provided by Iowa Code 284. It was the Sibley-Ocheyedan Community School District who, in their policy, decided they would implement a 6-month minimum. What that tells me about that particular school district is that they absorbed the intent of Iowa Code 284 to improve teacher quality, which is in part, it is the only way we improve student achievement. And in that, they recognize that there has to be a minimum amount of time that a teacher is allowed to remediate deficiencies and to receive assistance and feedback. Those important things did not happen here. The Iowa Code 284 informs the district's policy. It defines intensive assistance as substantial supports, feedback, technical assistance if it's needed. It's very specific about what that assistance is intended to be, and it's robust. It is not walking by a teacher's classroom and taking down a 3-word note. It is not standing outside of a teacher's classroom and looking in the window. It is sitting down with a teacher, regularly reviewing the intensive assistance plan, and giving them feedback about their practice, how it's improving, how it's not improving, the improvements that need yet to be made.
I hear you. Would you agree with me if this case were coming up in 2016 and not today, that this wouldn't be an issue, assuming the school district could establish good cause for termination?
Justice Mansfield, you bring up another clarification that needs to be made. I think the board misstates the state of the law and the legislative history of 284 when they suggest that this is a new law in 2017. What happened in 2017 is 284.8 was amended to provide that a teacher can only be on intensive assistance for any particular standard one time, and that they are not entitled to be placed on intensive assistance a second time.
Read the language that about terminate the teacher's contract immediately pursuant to section 279.27, which is the good cause provision, right? Yes. So in your view, it essentially, and in the view of the Court of Appeals, what the legislature did in 2017 was essentially create a safe harbor. In other words, the teacher could not be terminated for good cause during the duration of the IEP, a situation that did not exist prior to 2017, right?
Justice Mansfield, I believe that if I were arguing this case in 2016, I would argue it the same way. Because I think that that new language in 2017 just specifically sets out and refers to Iowa Code 279.27. If the intent of 284 and the express language is complex.
I mean, I think the Court of Appeals, and I think is, I agree with him, it's significant that that you have this provision that at the conclusion of the IAP period, you can terminate if you're the district, terminate the teacher's contract immediately, which implies you can't terminate it before. That's added in this 2017 legislation that I know the ISEA vigorously opposed and was supposedly something that was supposed to give more rights to management and to school districts. And I mean, sometimes the legislature does things they don't intend to do, but is that really, is that what happened here, perhaps?
I can't say that whether or not that is what happened here. I would continue to argue that pre-2017, a teacher had the right to participate in an intensive assistance program, and the school district had an obligation to provide one before they could terminate a person for cause. I think that is just clear. I think what everyone understood the law to say in 2016 just crept out in the legislation that was passed at that time. So I believe that has always been the law. We just haven't had this case yet.
Address the board's position that the grounds for termination here, just cause, were separate, distinct, and fell outside the scope of the IAP.
Yes, I can, Justice McDonald. And I think Justice Oxley is correct when she said that this is an argument that is new. But let me tell you this. 284.3 sets out the Iowa teaching standards, okay? And Ms. Braaksma was cited by Principal DeZeo as failing to meet 6 of the 8. Just as one single example, and I could give you more, the first standard provides that the teacher must demonstrate an ability to enhance academic performance and support for and implementation of the school district's student achievement goals. If failing to teach Spanish 2 and 3, or failing to teach it appropriately according to the curriculum isn't included in that standard alone, I don't have a better answer. If you look, and this is all set out in my resistance to the application for further review. If you look at the alleged citations in the evaluation from 2019, there are clearly some questions about her curricular delivery. So to say that this is completely new, I think misstates the record. And on this point, I would like to point out that if the allegation that she was failing to meet standards 2 and 3 are based on 2 student letters, 2 students who did not testify, and whose identity to this day, we do not know. We do not know the reasons for the letter. We don't know what precipitated these emails to the principal. If that is truly the basis and that was truly a concern about the teacher's performance, why would Principal DeZeo not immediately go to that teacher and say, I have concerns about what you're teaching in Spanish 2 and 3? Wouldn't have even had to mention any emails from students. Not to mention, there was never anything in the record that would suggest that Dana Braaksma was someone who retaliated against students or wouldn't take heed of those emails from students. Instead,
Agree at least with, I guess, the legal proposition that if she had engaged in some sort of conduct that constituted just cause that was outside the scope of the IAP, the board would have grounds to move at that point. The IAP doesn't create kind of a 6-month immunity from misconduct, right? I mean, okay.
284 addresses specifically performance related to the Iowa teaching standards. I think embezzlement, for instance, was one of the possible types of misconduct. Certainly, you would not put a teacher on intensive assistance under the Iowa teaching standards to deal with embezzlement. So to just move forward and go back a bit to the application for further review and our resistance. This appeal is before the court on pursuant to Iowa Code 279:18. And that specific provision requires or allows this court to reverse the district court and the board, for that matter, in the event that a termination was made in violation of Iowa law, in this case 284, a violation of the district's own written policies, or Dana Braaksma's teaching contract, which expressly incorporated those policies. In this particular situation, we do not have compliance with Iowa Code 284. The school district clearly followed the law and created a policy on intensive assistance, actually providing some more rights than the Iowa Code 284 provided. That particular policy required a 6-month minimum time on the plan.
I'm going to interrupt you. There was discussion about where the teacher allegedly refused to participate and then changed her mind. I want to look at that period in between. If she had refused during that 6 months, at that point, could they have said, you're out of here?
We had
6 months.
Very good question, and we addressed that. That question was asked by the Court of Appeals. Very legitimate question. So a refusal to participate in good faith in the intensive assistance plan is going to be a violation of the law. It's also going to be insubordination. And I think either one of those two items could be a basis for just cause. Those certainly aren't the facts here. I do want to go back to that time. I believe it was August 21st when the heated discussion of the intensive assistance plan took place. I think that you may have a bit of a he said, she said articulation of what happened in that meeting. Dana Braaksma certainly had questions. She certainly disagreed with some of the bases in which she was being placed on the plan. That probably isn't a shocking reaction to being told by your employer that you're not up to snuff, right? It is also not surprising that she would have these questions when the board policy allowed her to sit down with the superintendent, or the principal, her evaluator, and put the plan together. This plan was spoon-fed to her, which, mind you, probably doesn't elicit a whole lot of buy-in. It was given to her verbatim in a meeting. She was never told she would be allowed to ask questions, although the administrator suggested on the back end during the hearing that of course she could ask questions at the end, but she wasn't ever told that. So yes, she had questions and clarifications to be made.
Let me, ask a hypothetical. I'm not saying this is at all the facts of this case, but if hypothetically your client during the 2019-2020 school year was just every day turning on a Spanish language TV station and sitting in class with the students, are you saying that would not be just cause for termination? Or that she, let me put it this way, she could not be terminated until the completion of the IEP period?
Management and administration, that should never happen. That's why we have administrators to assure that teachers are doing their jobs. We have school boards to assure that administrators are doing their jobs. So if that in fact was, if it did happen, what should occur is remediation. That's what intensive assistance is all about. You go in and you sit down with this teacher and say, we can't show Spanish videos every day. We're making that, this is going to be part of our discussion in remediating your performance. So in the instant case, what we have is a termination of a teacher in violation of district policy, which is very clear. We also have a violation of Iowa Code Chapter 284, a clear example of when the teacher termination law should work to protect a public school teacher in Iowa. We don't get these cases very often, so I appreciate the opportunity to be here. This is the sort of case when Iowa Code Chapter 279 assures that the termination of a teacher is a fair process and is not arbitrary. So I just ask that you follow the lead of the Court of Appeals, reverse the district court and the board in their termination of Dana Braaksma. I appreciate your time today. Thank you.
Thank you. First, one thing I didn't mention is that the importance of this case is obvious. The 300-plus school districts in Iowa are watching this. The comment was that the IAP was spoon-fed to her. Her testimony specifically mentions that Superintendent Bohr asked her questions and listened to her, and that she participated in drawing up the IAP. The one question I think that is important is for her to reject it, does she have to do that vocally? She did that twice to each of the superintendents. But does she also, by her action, just rejecting it by failing to follow, as Judge Whittenberg in her district court opinion cited the number of reasons that she failed to follow it, does her action of failing to follow it show a rejection of the IAP? If a teacher is rejecting it, are they required to wait 6 months when they're not performing as anticipated? And our position is that the discharge for cause then should be able to be used.
Counsel, isn't your argument that it was separate conduct in August that triggered this firing and not following the IAP?
But also, if in fact you're saying, well, the IAP covers, I'm saying, wait a minute, she rejected it anyway. So that either, I think we're covered under both of those. That the fact is it's a new problem and we're taking care of it. But if in fact you're saying, well, the IAP does cover, we're saying, wait a minute, she rejected that. And she rejected it not only vocally to both of her superiors, Superintendent Bohr and Superintendent Craig, but she also as indicated in the Wittenberg decision, Judge Wittenberg's decision, she ignored it and didn't follow it herself. And I'm saying that that action is the same as if she had told Stan DeZale October 1st, I'm not following that IEP whatsoever. And then the one other point I haven't mentioned is the provision in 279.14, parent 2, that allows the individual board of directors to set the standards, for each district. The board at Sibley-Ocheyedan decided after hearing the evidence that the standard for Sibley-Ocheyedan wasn't met. They heard the testimony on the IEP. They heard the testimony on Spanish 2 and 3. They made their decision. And inherent in that decision are all the problems they heard through 2 different sessions of testimony. And for that reason, we ask that the decision of the Court of Appeals be set aside and that you implement the fact that the district court should be sustained and the board of directors of Sibley-Ocheyedan should be sustained in their termination. Thank you.
And Ms. Hickman, the case of Braaksma versus Board of Directors of Sibley-Ocheyedan is hereby submitted, and the court will sit in recess until this afternoon's oral arguments. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.